Rolling. This is the FedSoc Films Podcast,
where we continue the conversation
sparked on film.
White on set.
You want to know what freedom tastes like? It tastes like this beer.
Take one.
This is, in fact, the classic solution in search of a problem.
Action.
That cannot help but be controversial.
Cut. With expert discussion and analysis. With the greatest legal minds on the topic today. The FedSoc Films Podcast. It's a wrap.
You know, when you think about it, the concept of a right to privacy is kind of weird. It's like, I've decided I can control what people are allowed to know about me. And the idea of a right to privacy, penumbras and emanations aside, sometimes I'm not entirely sure I understand what that means. Hey there, and welcome back to the FedSoc Films Podcast. I'm Ann Hartley, your disquisitive host. We made a film called Katz on the Internet about the third-party doctrine and privacy in the United States. I have here with me John Richter, a partner at the law firm King Spalding and a former United States attorney, to discuss the right to privacy. Welcome, John.
Hi, Ann. Great to be here.
Glad to have you. So I'm curious what you think of the idea of a right to privacy. How do you understand that?
I think this is a concept that gets used, obviously, in a lot of different areas of the law. But more fundamentally, I think there is some sense that we all have in our society, in American society, that we should have some aspects of our lives that we can feel confident are free from the intrusion of others, and particularly free from the intrusion of the state, if you will. And that notion of individualism, and I think, and our ability to control ourselves, and the notion that the government is of the people, by the people, and for the people, embodies in it a sense that we have individual rights and we have an individual space that cannot be easily intruded upon. It obviously applies in the context that we've discussed in the notion of Fourth Amendment and what is a reasonable search and seizure. But of course, it also applies in other debates that we're looking for, and in Supreme Court jurisprudence, and most notably, of course, in matters of contraception and matters of in the debate about abortion and life, and it arises in the context of medical procedures and who makes decisions. But basically, when life is involved, or our personal lives are involved, the notion of having some space free from the state is implicated.
So it really is, in your opinion, tied up with the whole concept of an individual and individual rights as separate from the state.
That's how I see it. Obviously, I'm sure there are other views, and as a matter of philosophy, more to say about it. But I think, there is some sense that the privacies of life should be secure against arbitrary power, and that I think has been long recognized at some level as a norm in the United States and a norm embodied in the law.
Yeah, I don't think there's any question that that's the case. I do think it's kind of funny, though. I'm trying to think, is there anywhere in the Constitution that the word privacy is actually used?
No, there isn't. And that, of course, is what makes this concept in the context of discussion about what the Constitution holds as it pertains to rights where the notion of privacy is implicated. That's what makes it complicated and so heavily debated.
Oh, no doubt about it. It seems like it's been a hot topic for quite a while now.
No doubt about it. And obviously the Fourth Amendment is probably the least controversial of the areas in which the notion of a right to privacy is debated.
Mm-hmm. So do you think we can suss out a little bit, at least, of what the founders thought of, what we would consider privacy from the Fourth Amendment?
Yeah, there's certainly a fair bit to be gleaned. At the time of the founding, you've got to really think about that our Constitution and the notion of rights was embodied in the idea of negative rights, right? The right to be free from something as opposed to an affirmative right. And so I think as you think about that, what the founders were concerned about was drawing lines as to how the state would stay out of the lives of individuals, as opposed to thinking about it as an affirmative right to something that each person has. Those two, negative versus positive rights, obviously can overlap, and once you think about it in practice. But basically saying you're free from the state in these categories is different from saying the state awards you the right to something. And it is that former view that I think was most important to the founders, and really is what informs our Constitution, and particularly the Civil Rights Amendments embodied in the original Bill of Rights. And so I think at the end of the day, I think many scholars would say that at the founding, a search of a person, for example, did not mean a violation of someone's reasonable expectations of privacy. It was just simply to, understood for its common meaning to look for something, or to try to inquire and obtain information. And so there is no notion of privacy that appears, in before the 1967 Katz case in any federal or state case reporters, or the papers of the founders, or early congressional documents, or sort of seminal English texts that informed many of the founders' views in this area. So what I do think is that the notion of privacy was wrapped up in, at the time, really in the notion of security in property. That, of course, at the end of the day, the rule of law is about protecting property and securing property, because at the end of the day, if the state can take your things without appropriate process of law, you live in a lawless society. And if others can take your things, you live in a lawless society. So I think the security in property was seen as kind of the predominant concept in English law at the time. And if you think about some of the philosophers and speakers, going back in history, certainly Blackstone talked about every man's house is looked upon by the law to be his castle. And one of the great chancellors, Koch, for a man's house is his castle. And the political philosophy of John Locke, of course, that permeated, I think, 18th century political thought in America. For Locke, every individual had a property right in his own person, and anything removed from the common state of nature and that he mixed his labor with was his. And since property was very unsecure in this state of nature, if you will, the idea was for governments to obtain, that individuals would form governments to obtain a secure enjoyment of their properties. But that once that government was formed, the government couldn't have a power to destroy what was sought to be secured by the use of that government. So I think at the founding, this notion of what is private is heavily influenced by security of property. And that, of course, was a reaction to the American colonists who were very hostile to the then British Crown's writs of assistance, which were general warrants that essentially gave customs officials blanket authority to search where they pleased for goods imported in violation of British tax laws. And so the Fourth Amendment is I think seen generally by historical history scholars as as a reaction, essentially, to these writs of assistance, and ensuring that searches, therefore, needed to be particularized and could not be so general as those warrants were. And obviously, the founders, I think, would have understood that by securing property, that would also protect their privacy insofar as that went. But I don't think that this sort of more abstract notion of a right to privacy, at least from what I've read, really inhabits directly the thought of most of the thinkers and thinking that informed essentially the language that ultimately went into our Constitution and the Fourth Amendment.
Gotcha. So this really started out as something that was a very tangible protection against the government intrusion.
That's certainly what a lot of the history would suggest. And again, what we know about life, at least in my experiences, is that one generation's solution can sometimes become the next generation's problems. And of course, this notion of property is not the only part that inhabits this ideal that we have to some range of privacy that we all feel probably we deserve to have. But where that norm comes from and how it is essentially secured as a matter of law, I think is what is subject to debate in these other contexts in which the notion of privacy arises.
Sure. So do you think we've moved too far away from the founders' conception of privacy?
Well, again, I'm not sure the founders had the conception in the same way that we do today. And certainly when we talk about, in the Katz case, this reasonable expectations of privacy, I think there's a fair bit of scholarship out there that calls into question how that as to whether that really is defensible as a matter of constitutional interpretation. What I do think is that as society has evolved and technology has evolved, we don't have to just rely on the Fourth Amendment of the United States Constitution or our Constitution itself or other amendments to inform how we want to protect ourselves from arbitrary intrusions of the state. Obviously, there are other ways in which, through positive law, our legislatures and our elected officials can ensure that those more modern sensibilities of privacy are protected. And the Congress has done that over the years. Obviously, there are protections and rules about the use of wiretaps. There are other restrictions on in law as to what law enforcement can and cannot do in terms of process. But whether we're talking in the context of law enforcement and when law enforcement can seek certain information, or we're talking about other notions of protection of what is deemed to be information for which there is some privacy interest that, in the wisdom of our legislators, should be protected from use or arbitrary intrusion upon. Obviously, that's what laws can be designed to address. And that positive law that can obviously help inform and further inform what is an unreasonable search and seizure and what is, in fact, a person's papers or effects. I mean, if Congress were to say that, as a matter of law, certain information in the possession of private parties found on servers as a result of certain types of electronic communications, that individual citizens have an interest in those in some fashion, even if they don't own the information, that in and of itself can help inform when the government can use or take a particular action to gather that information. Again, Congress has to balance that, and state legislators have to balance that against, the need for law enforcement to be able to act reasonably nimbly when it has information and needs to take action that also in a way, protects us, because obviously being free from the state is one notion of being free, but also being free from other people who may harm us or take our things is another notion of freedom. And both have to be satisfied ably in our society if our government is to be respected and supported.
Absolutely. It's really funny. It does seem like at the end of the day, it really comes down to the two sides of the coin, right? It's you're talking about privacy and then you're talking about security. We've seen this play out, all over the place. I think the most notable thing a lot of people might think of is the Snowden incident. So how do you think we balance people's views of their privacy with this whole question of security?
Well, I think we balance it through our democratic process. And at the end of the day, facts will matter, circumstances will matter. And at some level, the wisdom of our founders was that our legislature would embody the views of the people and in different ways, right? Our House of Representatives would be the House that would be, I guess, most closely attuned to the daily whims, or at least whims in every 2 years of the American people, and that the Senate would be a cooler chamber with a little more distance, with 6-year terms, and of course, as originally envisioned, elected by the state legislatures, not even direct election by the people. And at the end of the day, these kinds of compromises are probably best suited for debate and resolution in our democratic processes rather than judges calling every single ball and strike. Of course, the facts of cases and in criminal cases, when judges' motions to suppress are filed and judges are having to make a determination about whether the Fourth Amendment was violated, there's plenty of room there for courts to make judicial determinations. But when we're dealing with this emerging technology, I think the unsatisfying aspect of the recent Supreme Court jurisprudence is that the court can't seem to find a consensus very easily on how you get to where they want to get. And so, any Supreme Court opinion, any judicial opinion that doesn't come across as completely intellectually honest, ultimately in hindsight becomes unsatisfying and confusing for readers. And I think the court right now continues to struggle with how do we balance and take into account the plain language and these notions of property interests and security and property from the founding with this more malleable Katz reasonable expectation of privacy test. How do they deal with that and how do they apply that when they're dealing with emerging technologies that don't make it quite as easy to see how the original text at the founding in the Fourth Amendment would apply, or they don't like the outcome and they want to extend some more protection and believe that somehow law enforcement shouldn't be able to get there without a warrant, and that may be fine, but to the degree it's not wedded to a really intellectually coherent test, it can be rather unsatisfying and frankly really hard for lower courts to be able to apply the rule in these contexts. So I think that's a long way of answering your question, Ann, and I hope I have, but it's suffice it to say that none of this is really easy, but ultimately it should be up to our democratically elected leaders to help us define these circumstances so that everybody knows what the rules are.
Absolutely. Sounds like there's definitely some more clarity to be had there. Well, thank you again, John. It's been a pleasure to have you on the podcast.
Well, thank you, Ann. My pleasure. Happy to be here.
Glad to hear it. And thank you, folks, for hanging in there. You can find the link to our film, Katz on the Internet, in the description on our YouTube channel or at fedsoc.org. That's FEDSOC.org. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. That's a wrap.
This has been a FedSoc audio production.